Our next case for this afternoon is 2020-30256, United States of America versus Sonny Scott. Ms. Rhoads, you may proceed.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Celia Rhoads with the Federal Public Defender's Office, and I represent Mr. Scott. This case involves an ineffective assistance of counsel claim based on counsel's failure to file a suppression motion that would have resulted in the exclusion of all of the evidence against Mr. Scott. The district court hinged denial of that claim on Strickland's first prong, deficient performance, which asked whether counsel's representation was objectively reasonable under prevailing professional norms. And to meet that standard, a decision not to file a suppression motion must be strategic, conscious, and informed. It wasn't in this case for two independent reasons. First, counsel didn't understand the relevant facts or law necessary to make an informed decision. And under this court's case law and Supreme Court case law, an uninformed decision is not sound and strategic. Second, even if counsel's decision had been informed, it was not objectively sound strategy. It was legally and logically incoherent. Now, as to the first issue, the government doesn't seem to deny that counsel's decision rested on foundational mistakes of fact and law. But those mistakes are fatal because counsel's decision by definition cannot qualify as strategic, conscious, and informed because it was built on a rotten foundation. Under Cabot, a lawyer who's not familiar with the facts and law relevant to a client's case cannot meet the minimum level of competence required under the Sixth Amendment. And that's important because although courts generally will defer to counsel's tactical decision-making, courts don't defer to decisions that are based on faulty information, rightfully so, because it's impossible to make a strategic choice under those circumstances. Now, the most obvious factual mistake that counsel made was that she clearly misread the information in that critical DEA report, which provided the entire basis for the search of Mr. Scott. And a good example of that is on record page 689. As the record reflects, agents were at the same hotel parking lot as Mr. Scott on the night of the stop because they were attempting to surveil a drug suspect and his black SUV that was parked in the same parking lot. Counsel claimed she didn't challenge the stop because agents observed Mr. Scott transacting with their target. And after that interaction, the suspect got into the black SUV and left. That was absolutely wrong. Mr. Scott never interacted with anyone related to the drug operation or anyone even known to the DEA. And the report made that clear. And so did Mr. Scott. He told her that. So her decision was uninformed. It was based on faulty information. And that's fatal because under this court's case law and every other court's case law, Mr. Scott was entitled, at the very least, to an attorney who was apprised of the relevant facts of his case. Without
Ms.
that,
Rhoads, it sounds that you're telling us very eloquently that why the counsel didn't understand the relevant facts and but what do we do with the fact that the district court made a specific conclusion that Ms. Yazbek's representation was not deficient? Are we reviewing that on a fresh record de novo, like it sounds like you wish us to do? Or are we reviewing that under United States versus Puckett or some other standard of abuse of discretion? So how do we, you just pointed it out to us fresh, like it's de novo, but I'm a little bit confused on this. Could you help?
Absolutely. I believe that the government might have been mistaken when they stated the standard of review in their briefing. The abuse of discretion standard applies, especially in the 2255 context as opposed to 2254, to whether to grant an evidentiary hearing, which was granted in this case. And under a 2255 standard, where there's no deference to a state court, this court's review of ineffective assistance of counsel, so Strickland findings, is a question of mixed law and facts, so de novo. If there are individual factual findings, which I think there's actually very few at issue in this case, those are clear error. But the legal issues always will be de novo because we're in the 2255 context and we're not talking about evidentiary hearings. So that's why when
you're saying that the totality of the circumstances doesn't support a Terry stop at all, and that would have carried the day.
Oh, absolutely. I think that the face of the DEA report, just reading Terry, I don't even think that you need to read any other case. There's obviously not reasonable suspicion under Terry. And there's extensive discussion of this issue in the record below 232 and 542, as well as 488. Agents simply believed that criminal activity was afoot, a drug transaction. That's what the DEA report says. It says they believed that a drug transaction occurred, but they didn't provide a particularized basis for that belief that was defendant and situation specific, as the law plainly requires. This is just elementary Fourth Amendment concepts. So like the Seventh Circuit said in Gentry, the fundamental principles of the Fourth Amendment law to this situation should have been apparent to counsel, and just application of that fundamental law here would have led to the obvious conclusion that the face of the DEA report obviously did not support reasonable suspicion. Because in this case, they only knew that Mr. Scott was in what they said was a high crime area in the same parking lot as a car, not even the drug suspect, but as the car of a drug suspect's car, and that he interacted with someone who the agents knew nothing about. It wasn't the suspect, contrary to what counsel believed. So certainly, to the extent, Your Honor,
what of a good faith exclusion application like in Ramirez-Lujan?
So do you mean because the belief was in good faith?
Yes.
So under Terry, good faith belief that criminal activity is occurring is not enough. There needs to be particularized, not only situation specific, but defendant specific information. And I think that's a good question, because I actually think that is the legal deficiency that counsel based her decision on. I counted at least 4 obvious mistakes related to Terry that counsel relied on. So first, her affidavit stated that she believed probable cause had been established by the information provided in the DA report, which is plainly incorrect and also not the standard under Terry. But second, to your point, she stated at least twice, and this was actually the theme running throughout her testimony, that it didn't matter what agents actually saw, that it only mattered if they simply believed that a hand-to-hand transaction had occurred. And she said this at page 724 and 709, but again, this was the theme that ran throughout. That is the exact opposite of what Terry says. Terry says that good faith belief is not enough. So in Terry, it wouldn't have been enough for the officer to say, I believe that a stick-up is happening. The reason why the facts of Terry were sufficient was that the officer provided defendant-specific, particularized facts to support that belief. So he said that if the 2 men were pacing back and forth, they were looking into the window repeatedly. He didn't just say, I believed that a stick-up was occurring. She also testified that agents could search Mr. Scott if they simply believed that a felony probably was committed, regardless of whether he was dangerous. And she also stated that once officers found contraband on this person, they were legitimized in that search. That is also plainly incorrect. These are misunderstandings of the most elementary Fourth Amendment concepts. And because her decision was based on those unreasonable mistakes, this wasn't a conscious and informed strategy. That is a threshold determination, which is what Hinton stands for, this court's case law, in Cabot, in Profit. There has to have been a conscious and informed strategy. Only then do we even ask whether it was objectively reasonable.
Ms. Rhoads, is there any evidence in the record to support your assertion that there's a reasonable probability that Scott would not have pleaded guilty to the possession charge, but for Ms. Yazbek's failure to file the motion to suppress?
Yes, so the district court made that initial finding in its first order and reasons, which I can find that record site. But Mr. Scott specifically alleged, first of all, that his plea was unknowing and voluntary because of this, which comports with this court's case law, and also that he would not have pleaded guilty but for counsel's advice. And I can find record citations.
Okay, so your briefing focuses, and I understand it completely, it focuses chiefly on the performance prong of Strickland, and I didn't know if there was anything else today you wanted to add on the prejudice prong.
Yes, so the prejudice prong, the reason why this can be brought in the 2255 context is because, especially in the case of a plea, is that the plea is rendered unknowing and involuntary, which is why, as a threshold matter, defendants have to allege that they wouldn't have pled guilty otherwise. Now, the evidentiary hearing, once the district court found that had been established, was limited only to the trial counsel's testimony. So that was specifically limited to her. To the extent that this court believes that there needs to be more factual support for that allegation, which Mr. Scott himself provided and the district court accepted as true, then a remand would be required. So we'd be permitted to put that evidence in the record as we're barred from doing. As of the prejudice prong, I do think that this court can affirm that determination on the current record. There's extensive analysis on this issue below, as I noted, and also just the face of the DEA report shows that any competent counsel should have known that this was facially insufficient under Terry. Now, to the extent this court disagrees, again, a remand, not affirmance, is required. There's no path to affirmance on this record because Mr. Scott was specifically prevented at the government's urging, so government invited error. Mr. Scott was prevented from providing any information beyond what counsel knew and believed at the time. So the district court specifically limited any additional information on prejudice and said, I'm just going to decide this based on the government's proffer. I'm not going to allow any other information on this point.
Quick question, which may honestly be better for Mr. Daly, but I'll give you a chance. So I'm just sort of confused on the chronology and how things sort of unfolded on that night. So agents were surveilling the parking lot, saw Scott in the parking lot, later arrested him at the Taco Bell. What was the amount of time between those two encounters?
So I don't think that the DEA report actually says the amount of time, if I'm recalling correctly. The agents established surveillance at 10:30. They then see, the government says that the black SUV arrived, but that's not what the DEA report says. They find the SUV in the parking lot. They then claim that Mr. Scott is interacting with another individual, provide no information, say that they believe that that's a hand-to-hand transaction. They then say that a person who turns out to be their suspect gets into the black SUV and leaves, and a short time later, Mr. Scott leaves the parking lot as well. It just says short. Did
they then follow him after he left the hotel parking lot? They just coincidentally ran into him at a different location at the Taco Bell?
It was totally different agents. And we have no information. It just says shortly after leaving the parking lot of the Stay in the Express and Suite, Special Agent Crow and Special Agent Ulmer were different agents, observed Scott in the drive-through the Taco Bell parking lot. Agents were set up at a Walmart nearby, and the person actually left to go to the Walmart because there was a controlled buy. They were meeting their confidential informant. Agents were apparently saw Mr. Scott at the drive-through on his motorcycle. We have no idea why they decided to stop him. The DEA report suggests but does not say that some sort of information was transmitted to those agents.
And in addition to the DEA report, do you know what materials Ms. Yazbek received from the government before Scott pleaded guilty?
It was only 31 pages. That was the sole production. In addition to that report, there were just, a lot of it was just photographs. Honestly, it would have taken probably 5 minutes to read in total. So it was photographs of the Jack Link's container, which is beef jerky container that they removed from his person. Inside was where drugs were found. And then the photograph of the gun, and then also his criminal history.
Did she request any materials in addition to those provided by the government?
No, and in fact, the DEA report, as you might see in the record, that's 213, is heavily redacted. And she didn't even request the unredacted version.
Did she conduct any interviews or meet with any of those DEA agents?
No, absolutely not. Didn't conduct any interviews with anyone, did nothing. So she received this 31-page production, and then less than 2 weeks later, about a week and a half, notified the district court that he would be pleading guilty. Did she conduct
any investigation of any measure about the events of that night?
None, not an ounce of investigation. Even after her client said there was no hand-to-hand transaction, this is incorrect. Even after the face of the DEA report made clear that the DEA did not have reasonable suspicion based on the information provided, she didn't seek out, she didn't go to the scene, she did literally nothing. She received the production, told her client he should plead guilty because he had no chance on the suppression issue, tried to get him to cooperate, that fell apart. At that point, they're still in the pretrial posture. So she could have still at that point filed a motion to suppress when it was clear that cooperation wasn't going to benefit him, but nonetheless went forward with this plea, developing a factual basis that has him admit to all of the facts relevant to drug possession. So she not only spent a week and a half with his case and had him plead guilty, she had him swear under oath without a plea agreement to facts that created further criminal liability. So she not only didn't help him in this case, she made his situation actively worse. And I see my time has expired.
Thank you.
Okay, Mr. Daly.
Hey, please the court. Good afternoon. Kyle Daly for the United States. The district court in this case conducted an evidentiary hearing, listened to the testimony of Scott's attorney, found her credible, and determined she reasonably decided not to file a motion to suppress. At the time that Ms. Yazbek made that decision, she knew that her client had a serious criminal record. He was arrested not only with the gun, but with baggies of heroin and cocaine and $250 in cash. She testified that she was familiar with the law regarding Terry stops, and she was trained on Terry as a CGA panel attorney. She had been filing motions to suppress and conducting hearings on motions to suppress for 10 years at that time. She reviewed the DEA-6 in this case. She testified that she considered the totality of the circumstances observed by the agents, including Scott's proximity in time to the dealer, the area, and the suspected drug transaction. She said that she did legal research on the issue and that she concluded the motion to suppress was unlikely to succeed. She was concerned and afraid that filing a motion to suppress could result in the piling on of additional facts that would cause the district court to believe that Scott was a drug dealer and not just a user. She was concerned because based on her past experience in other cases, officers had testified to facts not just in the report, but outside the report as well. And those facts were usually not helpful to her client. She was also concerned that the government might bring additional drug-related charges down the line. She advised Scott that the motion to suppress was likely going to fail and that it was better to try and cooperate with the government and plead guilty, and Scott accepted that advice. Ms. Yazbek reasonably believed that reasonable suspicion would be established at a hearing and motion to suppress would be denied. In this case, the agents knew that heroin was being sold at this specific hotel. They'd frequently observed transactions in public lots in the area. The incident occurred after 10 o'clock at night. It was in a parking lot behind the hotel. The heroin dealer arrived at 10:15 and Scott arrived 15 minutes later at 10:30. He met with somebody in the parking lot for a short amount of time, and he was there for only 15 minutes before leaving immediately after the drug dealer left. The agents, based on these observations and their experience, reasonably suspected that a drug transaction had occurred. There was no showing here that any further investigation by Ms. Yazbek would have unearthed anything that would have been helpful or changed the landscape for this motion to suppress. There was no reason for Ms. Yazbek to believe that the DEA agents would participate in an interview and give her the preview of the facts that they were going to testify to at the evidentiary hearing if she filed the motion to suppress. There were no other witnesses to interview other than Scott, because Scott claimed that he didn't know anybody at the hotel. And despite filing multiple memos on the ineffective assistance claim and retaining an investigator months before the 2255 hearing, Scott has not been able to articulate a single item of evidence that he has uncovered that would have changed the landscape on the motion to suppress and made it unreasonable for Ms. Yazbek to forego filing that motion in light of the concerns as to what might happen to her client if she pushed the case.
Mr. Daly, Mr. Daly, could you please tell us what standard of review governs our review of this case? So
the credibility of the testimony is clear error. There was only one witness who testified here, so clear error on the facts. De novo for conclusions of law reached by the court. So overall, it's an abuse of discretion standard.
What?
According to law, God save the United
That's
States.
not
the
same thing.
Good
Those
afternoon.
are two different standards.
Thank you for attending this Zoom
yes, Your Honor.
hearing.
Conclusions
I'm
of
very
law,
sorry
de novo.
that we weren't able to accommodate you
clear.
in New Orleans this
Right.
week. As it
That's the
turns
standard.
out, one
Okay.
panel of our court is having
Thank you,
some arguments, but
Ms. Yazbek's
Um,
actions leading
since
up
you
to
were the
plea,
only
and
panel
its
on which
sentencing
both
show that her
attorneys
decision
signaled your
was
willingness to
strategic,
show
and the
up,
reasons that she gave
we
at the
didn't
hearing
think it
were
made
indeed the
sense
reasons
for
that
us
she was
all to troop
concerned
down there for
about
that
filing the motion to
purpose.
suppress.
But
She
things are
testified
going to
that
change
including
pretty
the
soon,
drug
I think.
transaction in the
So
factual basis
that's something.
might verify in the district court's
Hmm.
mind
We do
that
have
Scott
a
was a
couple
drug
of
dealer. So she
adjustments
spoke to
or
the AUSA. She convinced the AUSA
extra rules
to
of the
remove any mention
road
of that drug
for
transaction
purposes
from
of
the factual
Zoom
basis,
hearings. One
and
is
the
we
AUSA
ask
did
you to
so.
silence
And she also
any other
successfully objected
devices you
to its
have
inclusion in the
or those
PSR, which
people in
avoided
the
a
room
four-level
with you.
increase in her client's
Second one is that
offense level
we
that the district court
still do the
was
audio
considering.
recordings of
It's
the
undisputed that
sitting,
there
but
was
we
no
will not.
actual
we do-
hand-to-hand transaction
As
that
in
was
New
observed
Orleans,
by
you're
the
not allowed to
DEA
video
agents,
or
right?
audio them for yourselves.
That's right. That's right.
If
Their
you
view
like,
So there
was
was
partially-
we
no-
will give you
Yeah, there was no
5
hand-to-hand
minutes
that would support
uninterrupted
this.
time at the beginning of your
Um,
presentation.
And
Just
so
because
what is the support
there's
for the
always a little
reasonable
bit of a gap
suspicion?
in communication here.
The
And
fact
then
that it's a brief
the other
meeting
thing I
in
would
the
say
back
is
of a
we will
hotel.
appreciate it.
So
both
they
of
do
your
observe a
cases,
meeting of some
record
kind. They don't know exactly what's
citations.
happened, but it's
We have
in
a time
close
clock
proximity in
system.
time
The yellow light will
and space to
tell
this
you
drug
that you
dealer
have 2 minutes
arriving
left, and when
and
the red
leaving.
light
So
signals,
the officers
we ask
only
you to
need
conclude
a
unless
minimal
you're
level of
answering a
suspicion
question
just to
from the
stop
court.
somebody and confirm or
The sole
dispel
case
their
this
suspicions regarding
afternoon
whether or
is
not a
number
transaction has occurred. And based on all the information that they
220416,
know about this
Polyflow
hotel
versus Specialty
and what's going on with the
RTP.
drug dealer at the
And we'll
time,
hear from
the
Mrs.
report is
Stratton
not
to
clear
begin.
as to whether or not
Thank you, Judge
who the
Jones,
individual
and may it
is
please the
that
court.
Scott meets with.
The
You
party's
can see that
contract
Ms. Scott-
says
I
that
mean, Ms.
any
Yazbek made a
action
number
arising
of
out of the agreement must
incorrect
be arbitrated.
statements about how
In
the
this
Fourth
action,
Amendment
Polyflow
works
alleges that
in her
appellees
testimony.
breached the agreement,
She
giving
made a
rise to
comment
various
that it
contract
could have been
and tort
interpreted by the
claims.
district court, but
But
apparently
the
was
district
not.
court denied
that
Polyflow's arbitration
The fruits of a
request.
stop could justify
This
a
court should
reasonable suspicion
reverse
for the
for
stop.
2
But
reasons.
when you look at her
First,
testimony as a
because
whole,
the
because she was
parties
asked questions about this
undisputedly
multiple
have
times
an
by both
arbitration
parties
agreement,
and the
the
court,
law heavily
the
presumes
district court
that
was within its
Polyflow's
discretion to
action
find
is
that she understood the
arbitrable.
law and Terry stop.
To
She
deny
understood that it was
arbitration,
the facts,
this court must
that the
have
agents
positive
observed
assurance
that leads
that
to
the
whether or not
arbitration
reasonable
agreement
suspicion,
cannot be
has
read
been
to cover this
established.
action. There is
And-
at least no
and
such
certainly
positive
her-
assurance
her
here.
testimony did not establish
Second,
that
appellee's
any
merits
misunderstanding
defenses
of
and
Terry
procedural
caused her
arbitrability
not to file the
challenge
motion to
are for the
suppress or would have,
arbitrator to
would
decide,
have changed
and
her
thus may
decision.
not preclude arbitration.
And she
To
was
begin,
wrong
the scope
factually
of the
about a lot of
arbitration
things
agreement
about
here
whether they
is
were in the
reasonably
report or
construed
not,
to cover
wasn't
this
she?
entire action.
She was
The
testifying
settlement
about what
agreement
she
requires
expected
arbitration
to hear
of any
at the
action that
evidentiary
arises
hearing.
out of the agreement.
Because this
The plain meaning of
report is
action is
vague,
lawsuit, the entire civil proceeding.
the
So the parties
officers
agreed
were
to
going to have to,
arbitrate the
fix
entire
these
civil
ambiguities
proceeding
at the
if it
hearing,
arises out
one
of
way
the
or another.
settlement
Now, it could have gone
agreement.
against her.
And this lawsuit
It could have gone
qualifies.
for her. And she was
First,
afraid that it would go against
this
her based on her past
lawsuit
experience.
exists
But
because of the
I wouldn't say
settlement
that her
agreement.
testimony,
And
that
the
she was
first
wrong
page
about
of
the facts.
Polyflow's complaint
She
at
was
1189 of
expecting
the record on
agents to
appeal
testify a
makes that
certain way
clear, stating
on
that Polyflow is
the
bringing
lack
this
of clarity in
action
that report
because the parties entered a
and her
settlement
prior
agreement,
experience.
but appellees have not complied with it and never intended to comply.
In some, there are countless ways to provide
Second, this
effective assistance to
lawsuit
counsel in any
includes
given
claims
case.
that appellees
Counsel's performance is
concede
evaluated
arise out of
based
the
upon
agreement.
time of the alleged error.
Specifically,
Can you
Polyflow's
excuse
claim
me,
and
sir.
appellee's
Can you provide
counterclaim
effective
for breach
assistance
of the agreement.
if you
So
do not
because this
vet or
action
even make a
unequivocally
cursory
includes
effort to
claims
look
that
into
arise
the
out of the settlement
applicable
agreement,
facts when
and
your client
indeed,
is
the
telling you
lawsuit
that the
only
facts are
exists
different?
because there is a settlement
depends on
agreement that
what-
we allege has been
It
breached.
depends on what there is to
The
look
action
into.
arises
So
out
you
of
can
the
you
agreement.
can do no
And the
work
plain
whatsoever
language
and
of the
still be
arbitration
effective.
clause thus requires arbitration.
You have to
of the
at least
entire
read the discovery
lawsuit.
that's given to you, talk to your
And
client,
this court
and then if there are
employed
leads
that
in
reasoning
that discovery
in its
or information from
2019
your client that you
decision
can
in
be
Archer,
expected
which
to
we
track
cited to
down,
the
then you
court
need
as
to do
supplemental
that.
authority.
But in this case,
The Archer
there was
panel
nothing to track down, and the
focused
fact
on the
that
plain
even
meaning of the
today,
term
the
action,
defense hasn't been able to
which
tell us of
meant the
anything that they've
entire
tracked down that
lawsuit,
would would help,
not just individually
Scott in the motion to
qualifying
suppress,
claims.
shows
And it
that there was
refused to
there was
rewrite
nothing
the
for her
arbitration
to-
agreement
no roads
there
for her to go
to
down.
encompass only
There's,
individually
certainly no
qualifying
case law that
claims.
indicates that
And
an
I
attorney
think it's
can
important to
is,
note that
ineffective for failing
the
to-
reasoning
Say there
that
are no-
Archer
go
used
down, but if the
applies
client
with
says
even
it
more
did not
force
happen
in
this
this
way.
case, because there,
This is
Archer
flatly,
involved an
emphatically
exclusion
untrue.
from arbitration.
Is that not?
So
I
the
used
plain
word
meaning
lead
of
earlier.
action, the
I don't know if that's
exclusionary
a
language,
lead
had
in
to
the
be
dictionary
enough
sense,
to
but
overcome
It's certainly a
a
road to travel
presumption
down,
in
it
favor
seems to
of
me.
arbitration. Here, The plain meaning of any action governs what is included in arbitration. So in
there's
this
nothing
case,
for her to do with that
the contract's
information
plain
that
language
anybody has
and the
been able
presumption in
to
favor of
establish.
arbitration
Yes,
are
she can
rowing
call
in
her
the same
client during
direction.
the motion hearing and have them testify to
Now,
that. But if there's no evidence
appellees have
that would
contended
corroborate
that the
then there's nothing
settlement
for her
agreement
to look into.
deviates from the plain meaning of action and specially defines action to more narrowly mean only
kind of take it upon
claim.
herself to
But the
conduct
contract
something
does not
resembling
support that
an
argument.
investigation. If her
You
client
can see the
says,
settlement
"It didn't
agreement
happen
at
this
tab
way,
4 of our record
here's what
excerpts.
happened."
And if you look in
Doesn't she
subsection
have,
A on the very first page, you'll
some
see that the
professional
settlement
duty to
agreement
try
does
to
not
get to the
define the
bottom of
term action. So under
Only if
ordinary
there's
contract
something
interpretation principles,
specific for her
the
to
plain
do,
language
Your
of the
Honor. That's
term
our
I
position.
can think of something specific.
Entire
She
civil
could go to
proceeding.
the scene
What the
and bring a
settlement agreement
friend
does define
and
at A1
demonstrate
is the
that the
term
view was
claim.
obstructed.
And it
where the
defines it
officers
because it's
were,
going
and
to
that they
use that
couldn't have
term to
seen the
describe what
hand-to-hand
is being
transaction.
released by the
In
parties
that
in
week and a
the
half,
settlement
she could have
agreement
done
and
that
released.
one
So
thing,
it defines
which
claim
doesn't
extensively
require a
to
lot of
include
money
not
or
only claims,
research
but
or
also
an
demands,
expert.
actions,
Maybe you'd bring
causes
an
of
expert
action,
to
so
say
on and
about
so forth.
visibility.
All
but
that this
yeah,
means,
I don't know
however,
that
is
you
that
need
when the
that.
settlement agreement uses the
Why,
word
I
claim,
mean,
it
isn't
means
that a
to
basic
incorporate a more
thing? If someone's
expansive
saying,
meaning.
I saw someone
It
do
does
a
not mean
hand-to-hand, or
that when the
it's
settlement
unclear
agreement
whether they
uses the
did,
word
to
action,
establish
as
that,
it does
no,
in
you
this
could not have
arbitration
seen
agreement,
that.
that the parties intended to more
If she
narrowly
knows
constrict
where
the
the
plain meaning of
officers
that term
were
to mean
viewing her
only
client from,
claim.
and if she
Well,
knows
shouldn't
that
she
And in
figure
fact,
that
Your
out?
Honors,
She should interview the people
A1 of
and
the
figure
settlement
it
agreement
out
that
and get
defines
it from
claim
the
shows the
report
parties
and ask for
understood
supplemental
there is a
information.
difference between
That's
the word
all
action
something she
and the
should
word
learn
claim
at the
because they
scene
define
of the
claims to
crime,
include
the alleged crime.
claims, actions, and causes of
When-
action, showing that they
when the
understand
attorney
the
is
difference.
stuck with the words of the
So,
police officers,
we
if these
contend,
were civilian
with
witnesses
the
that she could
support of
interview
Archer
we'd
and
have
other
reasons to believe
authorities,
Why is she
would
stuck?
participate
that
in
this
it.
any
interview
action
the
clause
DE? Why
is
couldn't she meet with
unambiguous,
and
and
interview
the
the DEA?
entire lawsuit
Well,
must be
any attorney
arbitrated.
could try,
But that is at least a
as the Seventh Circuit
reasonable
found in Rule in the case that we
interpretation
cited,
of
there's
the
just
arbitration agreement.
there's no
And
reasonable
so in that
expectation
case,
that
the
these
standard for
law
denying
enforcement officers
arbitration
are
is
going to
not
participate
met
in an interview.
because this
Would have
court
been
can have no
unreasonable of her
positive
to try,
assurance that this agreement is incapable of being read to cover
a
this
reasonably
action.
competent attorney doesn't have to expect that they're going to participate in
I'd
that
like to
interview.
turn
You don't
now,
dispute-
unless the
when I
court
asked Ms.
has
Rhoads
questions
whether,
about the scope of
the
the
lawyer
arbitration
conducted
clause
any
to appellee's
investigation,
asserted
any
defenses.
investigation.
Let me
about
ask
the
you one
events of
question.
that night.
When you say
Ms. Rhoads said
arbitration
no,
clause,
nothing.
the
You don't
settlement
contest
agreement
that,
has
do you?
2 paragraphs discussing arbitration.
We
Are
do
you
contest it to
referring
the extent
to
of,
B5C
well, it depends on what you mean by an
or
investigation.
C4,
If an investigation
or how
means
are we
hire an
supposed to
investigator
interpret those
and
provisions
ask that
together?
investigator to go do something in particular, she did not do
C4
that.
is the clause
investigation
that I'm
that she
referring
conducted
to.
was talking to her
Polyfus'
client
position is
and,
that
reading
based
the
on the
discovery,
text and
which,
context
for
of the
instance,
settlement
Kimmelman
agreement that
was what the Louisiana
C4
Supreme Court,
is the
or
arbitration
United States
clause.
Supreme Court
Discovery, the
B5C
31
is
pages, I think it was,
essentially
that
belt and
was handed to her. She
suspenders.
didn't
It's
request
additional
anything beyond
language
that.
that
Is
also
right?
underscores
No,
the
and there's no
broad
indication that
intent
there
of the
was anything
parties
else
to
to be provided
arbitrate
to her.
a broad
As far as you
range
know, she
of
did not
disputes.
undertake
And so
any
when I'm
effort
referring to the
look
arbitration
further
agreement, I'm referring to
into the
C4,
facts
but
of this
B5C, as we've
alleged
argued
or
in our
this
brief,
hand-to-hand
is
drug
further
transaction
support
that
for the
the
argument
agents
that there's no
believed
positive
that they
assurance that the
observed.
parties agreed to exclude
No, as
any
far
of
as
the
we know,
claims
there
in
was,
this action.
she did not do anything else because she didn't feel that there was anything else to have been done. And that was what the district court
thanks.
found, was that her decision
I'll turn
not
now
investigate
to
further was
defenses.
reasonable in light of all the facts.
This
that she
court
knew.
should hold that the issues of release,
I
prior
have a
material
further
breach,
question
and
about
lack of
the
mediation are for the
strategic
arbitrator to
reasons.
decide. This court's
To me, it's
inquiry, when faced with a
counterintuitive
request for
that
arbitration,
I'm not
is
going to
very
do
limited.
anything that might
The
benefit
court does
my
not
client
address the
because
merits,
I want to put
but
my
asks
client in the
only
best
whether an arbitration
position.
agreement exists
It would be
and
my
whether the
understanding
subject
that
matter of the
I would at
dispute
least
is within its scope.
threaten
Where
or
the
not threaten in a
existence
negative
of the
way, but at
contract
least
is
suggest
not
that
at
I might bring a
issue, as
motion to
here.
suppress
The
in order
only
to
defenses a court
negotiate
may consider
with
are those
the-
that specifically
with the
relate to the making of the
prosecutor,
arbitration
that I
agreement
would say,
itself.
I'm going to do this
Defenses
and
that
that and the
apply
other. What
to the
can you give
continuing
me if I don't
enforcement
do
of the
that?
contract as a
not
whole, or
say,
for the
I'm just gonna try
arbitrator
to
to
be
decide
nice and
as
maybe
part
they'll
of the
give me
merits of the
something.
underlying
So
dispute.
I think you would
This court
negotiate
has
from a
held that
position of
repeatedly in
strength,
Primerica and Bank
rather
One,
than a position
in
of
Will Drill,
begging for
and the
something.
Supreme Court has held
I'm
the same
very,
in Prima Paint.
this
Here,
idea
appellee's
I'm afraid
defenses
that they might
that
bring up other
Polyflow has
things if I don't
sued
plead.
on released
Well, in
claims,
fact, they did bring
or
up
that
other
Polyflow
things
has
during the
committed a
plea.
prior material
And she
breach
could have tried
of
to
the settlement
negotiate so
agreement
that those
by
wouldn't come
firing
up.
the neutral pipe expert. These are not
They could
independent
have
attacks
structured
that solely
something that she
relate to the
wouldn't be
arbitration
subject to some
agreement,
other
but they
further
are
charges, or
merits
she's gonna have
defenses
those
that go to
dismissed, or
the enforcement of the contract more
for
generally.
her client.
And
Mr. Scott.
appellee's answer
I don't
illustrates
understand
that.
how
Their
this was
answer in the district
strategically
court, which this court can
beneficial.
find at Record on Appeal
I'll the actions that you
1324 to
Yes, Your Honor. All the actions that you
1325,
described
and I
would
direct
be
the court
reasonable, but
specifically
there's
to
countless ways
paragraphs
to provide
3 and
reasonable,
15, make it
effective
clear that they have
representation.
pled both
And
release
one of them is to,
and
if
prior
you're-
material
if you have a
breach as
legitimate concern
affirmative
based on
defenses to
the
Polyflow's claims
strength
on
of
the
the case
merits,
against your client factually
as
at
well
trial,
as using both release and prior material
things could get
breach in the
worse for your
form of
client. When
allegedly
you have other
firing the
facts of
neutral
other
pipe
crimes, like
expert
drugs being
as a
found on
basis
him
for their
and a suspected drug
counterclaim for breach
transaction.
of contract.
If you have a reasonable
So
concern that things
it's
could get
clear
worse,
from their
rather
answer
than
that these
than
issues,
fighting with the
release
government and trying
and
to
prior
push the
material
government,
breach,
you
these are
can be
merit
cooperative
issues
and
for the
you can advise
arbitrator
your
and not
client,
defenses to the making of the
to
arbitration
try and go for a
agreement for the
5K,
court.
which is what was done here.
Ms. Stratton, so let me
there's-
But there
move
wasn't much
back to your
cooperation.
first
I mean, it
issue
wasn't
for
like
a minute.
anything
There,
between,
you know,
she,
let's
I didn't
assume
see any
there's a
acknowledgement.
textual
We're going to
argument in
really
the
be good. And we need you
arbitration
to help us out
clauses
here.
for
And
looking
it wasn't a
at
good cop
this,
kind of version of
your
it either. It was a
complaint
nothing version.
or
of it.
looking through to your causes of
She
action or
talked to the client
whatever
about the meeting
on a
before the
piecemeal
meeting,
basis.
and it seemed that there was
One
an
of those
expectation that he was
is
going to cooperate, and that he backed off
fraudulent
on.
inducement to
So then she
settle.
was just left with
How do
having
you
attempted to
how do
cooperate
you
with the
square
government
that
and
with,
not much else.
arbitrating the contract?
In light of
And also,
the facts
what
in the
about
DEA
the
6 and what
tortious
she reasonably
interference
expected would be
claim?
testified
How
to,
does
the
that
decision
arise out
not
of
to threaten
the
that motion
settlement
or file
agreement?
it was reasonable.
So I'll turn first
She
to
could
the
have taken a
fraudulent
different
inducement
tactic, but
claim.
the tactic that she
It
took
arises out of the
was
settlement
nevertheless reasonable.
agreement for the following reasons. First,
Ultimately,
under
Scott has not
Texas
shown
law,
that Ms. Yazbek's
a
decision
fraudulent
was
inducement claim
unreasonable, and
cannot
much less
exist
so unreasonable
but for the
that she failed to
fraudulently
function as the
induced
counsel
contract,
guaranteed
and
by
it
the Sixth
requires the existence
If
of
there are
that
no further
contract as
questions,
part of its proof.
we ask that you affirm the
Our
district
claim
court.
is even
Thanks very
more
much.
dependent upon
Counsel,
the contract
Can
because
you win
in paragraph
on
80 of our
prejudice
complaint, we
without
allege that
us
it is
going back
misrepresentations
if you were
in
to
the settlement
lose on the
agreement
other
itself
prong?
that fraudulently induced us to enter
No,
the
Your Honor.
contract.
If this court,
And I'd also direct the
reason
court's
is
attention
because
to the following
we would
decisions.
presume
Prima
that this court would
Paint,
not find
Henry
deficient
Kaplan from the
performance
Texas
unless it
Supreme
was such a
Court,
clear, the motion
Burwell
was such a
from
clear
the Texas
winner
Appellate Court,
that no
Sweet
reasonably
Dreams from the
competent
Seventh
attorney
Circuit,
could,
as well as this court's own
could
decision
choose
in
not to file it.
Marlin,
So,
which involve broad
if you
and narrow
find
arbitration
that
clauses.
this
And this
motion
and
was
the
a clear
courts held
winner
in
and
all
had
of
to have
those
been
cases
filed,
that fraudulent
then
inducement claims were
then you're
arbitrable,
going to find it
whether
was a clear
the
winner for the
clause was
prejudice prong
broad
as well.
or narrow.
And we acknowledge
As
that
for
there's
the
no
tortious
reasonable probability that
interference
Scott
claim, Your
would
Honor,
have pled guilty.
these claims
had
are
this
specifically
firearm
predicated
been suppressed,
on
since it was the only
misrepresentations
evidence
and
against
So we
omissions
don't send it back
that we
at all.
allege appellees made to third
we should
parties
just render.
about the settlement agreement itself.
That's our position, Your Honor.
Okay.
These
Just so I get it straight, your
misrepresentations and
view is
omissions are
that
pled at
if-
paragraphs
if Scott
64 and
satisfies-
68
if
of
Scott
our
kind of scales
complaint,
that performance
and they are
prong,
incorporated by
that he
reference into our
necessarily
causes
scales
of
the
action at
prejudice
paragraph
prong.
70.
In this
And
case,
you'll also
where
find them
where the
incorporated
only
by
evidence
reference
against
into the
him is the
tortious
gun and the
interference
government
claim at
cannot,
paragraph
proceed to trial
117.
without it, then yes.
And so we
under the
allege
unique
that the
circumstances
breaches
of
of
this case,
duties
yes, that's
imposed by
our
the settlement agreement, the use of our information,
Thank you, Your Honors.
the misrepresentation about our relationship is what caused tortious interference with business relationships. And this court has made clear in numerous cases, as have Texas courts,
Thank you, Your Honor.
that a breach
there's a
of
couple of
contract
quick
can involve
factual,
tortious
errors
conduct
I'd like
that
to
gives
correct.
rise to both
First
breach
about
of
the DEA
contract and
report,
tort
I
claims
think
at the same time.
like
And that's what's
Counsel,
happened here. It's why
the
our
government
tortious
is,
interference
inserting
claim
a couple of
arises
facts in the
out
DEA
of this
report that
contract
aren't there.
because it is
So one,
generated
it doesn't
by
say anything about
appellee's
Harold
alleged
Fields.
breaches
It
of
says
the
only that
contract.
this was believed to be a high crime
you
area
have
by
any,
agents and that they knew that this particular suspect
idea
when they were
why
surveilling
Judge
had been known
Hoyt
to conduct
disposed of this
transactions there.
in
As
one
far as I can tell,
sentence?
there's nothing about
And
heroin.
I'm
The heroin
looking
came
at
out
the
after
docket,
fact,
it looks as
which
if there
can't be
was
used
no
to
oral
legitimize the
hearing
stop. It also
on
doesn't
the
say
arbitration
that
agreement.
the
So
suspect arrived
I
close in time
do
to
not
Mr.
know.
Scott. It only
That's
says
quite a
that they
mystery to
found
us
the
as
car
well,
in the parking lot.
particularly given the
It
strong
also does
presumption in
not say
favor of
this was a
arbitration
brief meeting.
and the
There
broad
is
language here under
absolutely
numerous
no
court
information
precedents.
describing what that
So his
interaction was.
summary denial of
So this is
arbitration
exactly like
is
Terry,
quite a
two people
mystery to
standing
us,
on
and
a
it's why we're
corner
here.
interacting,
I
is
don't know
not,
the answer, unfortunately,
suspicious.
Judge.
I also want to correct that this was not a single
I would like
comment,
to turn and discuss failure of
showed a
mediation
misunderstanding
now.
of Terry. This was
Mediation is a question of procedural arbitrability, and procedural arbitrability is a question for the arbitrator in nearly all circumstances. This court has found that there's only one rare exception in which the court can decide a procedural prerequisite bars arbitration, and that is when it is clearly established that a procedural requirement is a condition precedent to arbitration and has been breached, such that no rational mind could conclude otherwise. That high bar for taking this question of whether mediation is a procedural bar to arbitration has not been, for taking that question from the arbitrator has not been met in this case. Because a rational mind could agree with Polyflow that mediation is not a condition precedent, or that if it is, it's been either deemed fulfilled or excused by appellee's conduct frustrating mediation. And before I tick through those reasons very briefly, I'd like to remind the court that under general warehouseman and other precedents, this court doesn't need to agree that Polyflow would prevail on any of these points. It need only conclude that a rational mind could agree and that these issues are not clearly established, such that it's the arbitrator's province to decide whether mediation is a bar. Mediation is not a bar and not a condition precedent because it's disfavored under Texas law. And I'd note that at page 30 of their brief, appellees have reversed course from their position in the district court, and they've argued to this court that mediation is in fact not a condition precedent. That seems at least suggestive that a rational mind could agree with Polyflow. The settlement agreement's mediation terms only apply to issues of B1 and B2 compliance. They don't apply to the other types of issues that are in dispute here. And even as to B1 and B2, they only apply when the pipe expert has made a determination that the appellees are out of compliance, which appellees concede never happened here. But even if it is a condition precedent, it's been deemed fulfilled by their failure to specifically deny it in their answer. But even more importantly, it's been frustrated by appellees withholding of their design and manufacturing process information, which is the earlier step necessary to even get to mediation. And this court has held that a promissor cannot take advantage of a condition, a failure of a condition that they themselves frustrated. And I see my time is ending, so I will reserve the remaining time for rebuttal.
As the district court ultimately found,
we'll hear from
this was actually properly before court. We said we have an investigator. We actually did go to the scene. And Judge Elrod, to your point, what we would have shown at the hearing was that agents could not have seen this transaction. We were able to corroborate Mr. Scott's claim, and that's what our investigator was sitting in the hallway ready to present. But for the government's invited error. Now, I don't think this court needs to reach that. Because I think that the current record plainly establishes that counsel's representation
was the developer of the technology that's kind of
like I said, I don't think there's any path to affirmance in this case, but I think there's a
he was a
clear
CEO
path
for a time,
reversal.
developed its product during that time.
Deficient.
At some point, the parties went their separate ways.
She made no effort
to set out to form Specialty RTP, where he remains today, and Polyflow continued with its business.
That undermines our entire adversarial
You've seen reference, and we've discussed it in our brief, that in 2015, Polyflow brought claims against Mr. Wright and SRTP, and in fact, those claims are largely the same claims they bring now.
And the reason he requested it be removed is because it wasn't untrue.
That suit was ultimately resolved.
So we would ask this court to reverse the district
really
court's
best described as the nuisance suit, and that's evidenced by the fact that if you look at the settlement agreement, no money changed hands there. The heart of that agreement is sections B1 and B2.
We have
and
your
those put
argument.
Restrictions on
We appreciate both arguments
Specialty
today.
RTP with regard to what information it can use and what products it could design or manufacture.
And
Mr. Wright and SRTP have never used Polyflow information, but the agreement provided that there was a mechanism for Polyflow to confirm on an ongoing basis whether any of SRTP's products did include Polyflow information. Of particular importance to Specialty RTP was the dispute resolution framework set forth in sections B4 and B5 of the agreement. And what those call for is the appointment by an arbitrator of what's referred to as an RTP expert or a neutral pipe expert. And that was a person that was neutral and also knowledgeable about the technology and the products that were involved from both Polyflow and SRTP. And that framework requires that the pipe expert examine any products that Specialty RTP intended to manufacture or design for a time period and make a determination of whether those products violated Section B1 or B2 of the settlement agreement. And the reason this framework was set up this way, and the reason that there was a neutral expert put in place, was because Specialty RTP was particularly concerned that Polyflow would use this mechanism to discover or learn about Specialty RTP's technology. And so that's why they had this neutral expert in between, so that neither party's proprietary information would ever be shared with the other. It would all go to the neutral expert. He would make a decision, and the information would remain separate from the other party. Going forward, the pipe expert, once he made a decision, and as Ms. Stratton noted, if the decision was in favor of Specialty RTP, the pipe expert's decision was final. Only if he found that Specialty RTP was in violation would it then trigger a mediation process, and the pipe expert would attempt to mediate that dispute. And only if he was unsuccessful in mediating that dispute did the parties then agree to take that dispute to arbitration. And that is the arbitration provision that you see in Section B5 of the agreement. And it is specifically related to these disputes that may arise in the context of the neutral pipe expert and sections B1 and B2 of the agreement. But the important part of that is that the purpose was to prevent Specialty RTP's technology from falling into Polyflow's hands under the guise of policing the agreement. The second arbitration clause here is found in Section C4. It relates only to disputes that arise under the agreement. And that's very clear. The court, and I think on that point, the courts are clear, including in the Pennzoil case, that an arbitration clause that uses language such as arising out of is a narrow clause. And the court in Pennzoil contrasted that with broad clauses that use language such as arising out of or related to. That's clearly not what we have here. Under Pennzoil, the clause in C4 is a narrow one. That's further evidenced by the fact that the clause in C4 does not even cover all disputes that would arise under this agreement, because it's, as I mentioned, the separate dispute resolution mechanism set forth in Section B5 would cover disputes that fall under sections B1 or B2 of the agreement.
Well, I might agree with you if the arbitration provision in B5C said anything about limited to this agreement or this mechanism, but instead it says, for purposes of clarity, the parties are agreeing that any disputes arising out of or related to this agreement will be arbitrated. And aren't we, since and going a little further, aren't we required to interpret these provisions harmoniously and not one limiting the other or being limited arbitrarily as opposed to the other one? Go ahead.
Well, I think they do need to be interpreted harmoniously. I'm sorry, Your Honor. I think they do need to be interpreted harmoniously, and I think the way that that is done in this case is that you look at the agreement as a whole, and specifically in sections B4 and B5, it sets forth this dispute resolution framework that relates to as I mentioned, the neutral pipe expert and his duties to resolve disputes arising under sections B1 and B2. And then if you look, C4 then would cover anything else. And so otherwise you would, if you read section B5C broadly to cover all disputes that arise under or relate to the agreement, you end up rendering the clause in C4 a nullity. And that's what the parties intended here was that agreement or that clause in B5 would relate to the dispute resolution framework of sections B1 and B2, and that C4 then would cover any other disputes that arise under the agreement.
Well,
so with regard to
what's your best case? What's your best case?
With regard to
you and I, your transmission is a little slow. I'm sorry, I don't mean to interrupt you.
I apologize, and I don't. It does drop occasionally, and I'm not sure why.
Well,
I think just the plain reading of the agreement, as you mentioned, requires those two clauses to be harmonized, and the agreement itself makes clear how to do that. Because it sets forth the framework for dispute resolution under B1 and B2 in sections B4 and B5. As I mentioned, where you have two competing clauses, and in this case they don't compete. But if you did try to read them on top of each other, one would just be rendered a nullity, and that shouldn't be the right result here. Further, I believe I understood Polyflow to say that they are seeking arbitration solely under C4 in this case. With regard to the argument that all claims, if any claim is arbitrable, all claims are arbitrable, and that's Polyflow's argument with the Archer case. Here again, the agreement makes clear that certain disputes, those arising under B1 and B2, do not fall under the arbitration clause in C4. And so at least one category of claims would not go to arbitration, even under that, or should not go to arbitration under Section C4. That's not what the parties agreed to. They agreed to have two separate arbitration provisions covering different aspects of the agreement.
So is it your position that you want part of this dispute arbitrated and part of it submitted to the federal court?
Well, we believe all the claims should properly remain in front of the court, and that none of them are arbitrable. And
well, you just said that B1 and B2 are arbitrable.
They are if and that goes to whether certain conditions are met, and as we describe in our briefing, those conditions just simply haven't been met. There's a framework, and it requires the appointment of an MPE by an arbitrator. That was done, and it requires the pipe expert to then examine SRTP products to see if they are in violation of sections B1 or B2. He's done that. In this case, he has not found a violation, and therefore, under the terms of the agreement, that's the end of that inquiry. However, if there was a case where he found SRTP to be in violation, only then, if he was not able to mediate that dispute, would that specific dispute go to arbitration under the provision in section B5.
Well, I mean, they assert that a number of their claims, they assert
in that way, then.
Okay, I'll try again. they assert that a number of their claims are based on disclosures of information contrary by specialty RTP, contrary to the settlement agreement, interference with customers of Polyflow, and Lanham Act violations. And it seems to me all of those are reasonably read as being governed by the settlement agreement. So why are they not arbitrable under C4?
Well, if we look at the Ford case, for example, the test for whether tort claims arise or relate to the agreement is whether those claims could stand alone. And so certainly the Lanham Act claims, which relate to trademark trade dress largely, those claims could certainly stand alone here. The existence of the agreement is not required to go forward with those claims. With regard to tortious interference, it's the same. The activities that Polyflow complains about which was disclosing information to certain customers, setting aside that may not even fall under the Lanham Act because it doesn't relate to goods or services. That cause of action would stand alone. It does not require the existence of the contract. And the same is true with regard to the fraudulent inducement claims. And that's, if we look at the Ford case, it addressed fraudulent inducement, Lanham Act claims, and tortious interference claims. And in each of those instances, it found that they did not relate to the underlying agreement and did not require the agreement. And in that way, they stood alone and were not arbitrable. And I will point out in that case that was a broad that did involve a broad arbitration provision that covered any claims arising from or related to the agreement, which is not what we have here. We have a narrow provision that only covers claims that arise from the agreement. And so with regard to Lanham Act, fraudulent inducement, tortious interference, they simply just don't arise from the agreement. They stand alone under Ford.
Why is it that your client decided not to do arbitration?
Polyflow has asserted in this case a number of claims that it previously released in the earlier case. And we've provided a comparison of those claims, and you'll see that they are, most of them are largely identical. And in fact, in the first amended complaint, Polyflow makes clear that it's relying on activity that occurred before the settlement agreement. And that's at record 1203 and 1204, where it specifically sets out before the settlement agreement, and then provides a kind of laundry list of bad acts that it claims SRTP is guilty of. Further, in the counts themselves, it refers to activity involving Exxon, Petronas. Both of those companies were part of the 2015 lawsuit. And so we don't want a case, and we think they should they should be resolved in federal court, not in front of an arbitrator. They simply do not arise out of this agreement. I mean, if we look at what the parties agreed to arbitrate, and that's really the focus here, what did the parties agree to arbitrate? It's very clear. They agreed to arbitrate only those disputes that arise out of the agreement.
And that's it. The word is action.
The word is action, and in this case, We contend that action means a claim or a cause of action. And we have addressed the Archer case in our response to Polyflow's supplemental authority, and that's further underscored by the party's definition of a claim in this case, where it defines claim synonymous with action, where the parties wanted to refer to an entire litigation. They did so. For instance, they referred to the 2015 litigation, or they refer to it as a civil action. In this case, action should be construed to mean cause of action, and that's further underscored by the fact that to read action as the entire action in C4 would then render any claims that arise under B1 and are required to be arbitrated, perhaps at some point under Section B5, it would render that a nullity, and that shouldn't be the result here. Going back to two issues, with regard to the release claims, I understood Polyflow to argue that is an issue for the arbitrator. It's simply not. In this case, those claims, the released claims that are now included in Polyflow's current complaint were released in the same agreement that the arbitration clauses are found. And so that is not, those claims are not something that the parties agreed to mediate. It perhaps could be a different result if the release claims were in a different agreement or something along those lines. But here they were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate them at some point in the future. With regard to the failure to mediate, the framework in Section B is very clear that if Polyflow believes that SRTP is in violation, it can raise that issue with the neutral pipe expert, and then he will go forward with his analysis and mediation if necessary to resolve the dispute. SRTP has complied with every request from the pipe expert with regard to providing products. So for examination, products and information. So to the extent that Polyflow claims that there are products that it believes are in violation, but SRTP has not turned over, that is the result of Polyflow not raising that issue with the neutral pipe expert in the first instance. And I see I am out of time.
Yes, sir, you're out of time. We'll go back to Ms. Stratton for rebuttal.
Thank you, Your Honor. I'd like to begin with the issue of mediation. You've heard opposing counsel describe their view of why mediation was a prerequisite here, and we obviously vehemently dispute that. And that's precisely why the issue is not clearly established such that this court could decide it, because no rational mind could do anything but agree with Mr. Schlather's position. He's not articulated why it is clearly established and essentially undisputed here that a procedural prerequisite was breached. So all of his arguments about what should have been done in the mediation process, that's all for the arbitrator to decide under this court's procedural arbitrability precedents. I'd like to also briefly discuss the issue of release. Appellees appear to be trying to take the issue of release and frame it as a question of what the parties agreed to arbitrate, a question of substantive arbitrability. But this court has made clear that it does not consider the merits in its substantive arbitrability determination. You said that in Chevron Chemical, you said it in Bank One v. Hill, and in numerous other cases. And what Mr. Schlather's argument does by asserting release as a question of the scope of the arbitration agreement is inject the merits into the substantive arbitrability determination. For this court to decide whether Polyflow released or sued on released claims, it would have to resolve the merit. That is a basis for Polyflow's counterclaim in this case. That's not properly before the court in a substantive arbitrability analysis. Release is a defense. That's how this court should treat it. And that's exactly how Mr. Schlather's answer on behalf of Specialty RTP in the district court treated it as an affirmative defense on the merits, a basis for their merits counterclaim, and therefore it's properly submitted to the arbitrator as part of the underlying merits of the dispute. Now, I'd like to move on to addressing the interaction between C4 and B5. There is a way to harmonize these provisions, to read them quite naturally in a way that doesn't treat them as two separate arbitration provisions or treat them as a limitation on one another. First, there is nothing in the text of either C4 or B5C that suggests that they apply to anything other than the entirety of the agreement. There is no limiting language, as Judge Jones noted. And the most natural reading we submit of B5 is that it is inserted to protect the breadth of the parties' arbitration agreement, because it appears in a section laying out certain procedures for resolving certain types of disputes under the agreement. And it heads off the potential argument that by laying out those procedures, these were the only substantive claims the parties intended to arbitrate. And so the text of B5 says very clearly, for purposes of clarity, we are clarifying that we are agreeing that any dispute arising out of or related to this agreement shall be arbitrated. And so in C4, you have an extraordinarily broad arbitration provision. In B5C, you have another extraordinarily broad arbitration provision, and broad plus broad equals broad. It does not, as Mr. Schlather contends, equal narrow, and it does not equal arising under, which is what he said at the beginning of the argument, that we agreed in C4 to arbitrate arising under. This court made clear in Explo that arising out of and arising under are not the same, and that arising out of is a broader arbitration clause than the more narrow arising under. It's Mr. Schlather's burden to furnish this court with positive assurance that this arbitration agreement cannot be read to cover this action. And in order to meet that burden, appellees have had to rewrite the arbitration language to arising under and call arbitration clauses that this court and others have repeatedly called broad narrow, insisting upon that. And our opinion, Your Honors, is that that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies upon. In Ford, the court made it clear that when a tort claim is based upon a breach of contract, it's arbitrable. There was no breach of contract claim in the case. The parties could have completely complied with their obligations under the contract, and the tort claim in that case would still have proceeded. That's why the Ford court was able to say, this contract is legally irrelevant to this tort claim. We can treat it like it doesn't exist. That's not possible here. For example, Mr. Schlather asserts that the Lanham Act claims have nothing to do with the settlement agreement, but I'd refer the court to paragraphs 96 and 114 of our unfair competition claims, which are based specifically upon appellees' misrepresentations about the terms and scope of the settlement agreement itself. The fact finder simply could not resolve those claims without consulting the terms and scope of the settlement agreement, and they arise out of the contract. Thank you.
All right, thank you very much. That concludes our brief hearing for today, and we'll take the case under advisement.
Thank you.